might be different to what Mr. van der Merwe can draw from the statements therein. Hence, it becomes prudent that same becomes evidence when the witness testifies, and the court thereto draws those inferences on the proven facts after the witness has given evidence in chief, cross-examination, and further. Hence, it is a state submission that same can be a matter of evidence, or rather is a matter of evidence. Therefore, the state submission is the reply to the request is sufficient. 1.5. On which dates and where did each of the accused act in the alleged furtherance of common papers? On page 17, and the reply is on page 19.
Is it 1.5?
1.5, Madam.
Might just point out it's not in respect of common purpose, but in respect of the
Conspiracy, sorry.
Just a minute. Oh, did you read something else?
Yes, it's slip of a tongue.
Actually, you read something else into this.
Yes, Madam.
Okay.
On which dates and where did each of the four accused act in the alleged furtherance of the conspiracy? Thank you to my learned colleague for bringing that to my attention. 1.5 reads, my lord, on page 39 of the bundle. The state submits this as a matter of evidence. However, at present, same is unknown to the state, save for the periods mentioned in several statements and or affidavits already supplied to the accused. Reference is also made to the statements already disclosed to the accused in general, and A48 and A77 in particular. Further reference is also made to paragraph 1 and 2 of part A of the indictment. One was saying it's a matter of evidence, my lord, which I submit same as one in 1.4. 2, it's unknown to the state. The dates there too. 4, 3 rather, the periods at least are mentioned in the indictment, in the statements already given or disclosed to the accused in general and in particular A48 and A77. 4, you are referred to paragraph 1 and 2 of part A of the indictment. 4, the conspiracy charge, there must be a meeting of the mind which amounts to an agreement.
Just a minute. Is it 1 and 2 of part A of the indictment or the summary?
I always make this.
In fact, here you have said it in writing.
Then my lord, correction is it is part A, paragraph 1 and 2 of part A of the summary.
Of the summary.
Of substantial facts.
No, thank you.
Thank you, my lord. As indicated in Cooper, when a conspiratorial agreement has been made, the offense of conspiracy is complete. That can be found in paragraph 2 of page 2 of 6. It has been committed and the conspirators can be prosecuted even though no performance has taken place. What I'm trying to indicate, my lord, here too is there must be a criminal arrangement. And we have indicated specifically on paragraph 2 of part A of the summary of substantial facts that we do not know when, where, or in what manner that such criminal agreement was entered into by the accused. 84.2 says, if same is unknown to the state, that will be sufficient. There won't be no reasonable need for additional information. Therefore, it's my respectful submission that same has been replied sufficiently to the accused, no need for the court to order further particulars thereto. Which leads me to 1.6 on page 17. In the event that it is alleged that the commission of these offences was of a continuous nature, the state is requested to indicate which of the accused acted during the period, the duration of each accused involvement, and the specific acts of each accused with reference to the identifiable dates attributed to each of the accused individually. The only difference between 1.5 and 1.6 is not only a specific date but a specific period, which we allege on the charge sheet or indictment that it was between July and September of 2013. We also allege in the paragraph 2 of part A of the summary of substantial facts that it is unknown to the state as to in what form this was done. 84.2 says that will be sufficient, and we beg the court to order that no further particulars or better particulars should be given to the accused. May I go to page 18, my lord, on paragraph 1.7?
All right.
The state is requested to furnish full particulars of the factual basis upon which it is alleged that accused 1, 2, 3, and 5 was involved in the perpetration of the offense. That's basically asking, on what evidence are you saying they have committed the offense? Hence, reference is made to paragraph 64 once again of the Erasmus judgment, that you are in possession of the statements. If I were to quote perhaps what Mr. Van der Merwe said when A77 was disclosed, his words were in this kind of line. We have now, my lord, received what forms the state's case. We have now received basically the core of the state's case. Just said along those lines. Basically saying, my lord, we now understand why the state have preferred these kind of charges against the accused when we are in possession of A77. If I understand those kind of words, this statement forms the factual basis upon which the state have preferred these charges. That's basically what he was saying. Therefore, it's there. Therefore, one can understand that A77 at least gives green light as to the question asked on 1.7. Hence, the reply thereto by the state is references made to 1.5 supra, where reference is on line 3 of 1.5. Reference is also made to the statements already disclosed to the accused in general, and A48 and A77 in particular. Therefore, if the court is informed by counsel that now we understand the factual basis upon which these charges are laid, how can, on the other hand, the court is informed that no. State must give further particulars of the involvement of my clients if some kind of an admission is already made. But no, I understand why the state prefers this kind of charges after having read A77. Therefore, my lord, it will be a duplication if we are to be ordered to disclose, or rather furnish full particulars thereof. I will revert back to the submissions I've made on the 18th of this month, that if we are not at idem, my lord, insofar as their request and reply, the only avenue open to the court is for the court to actually read perhaps A77 and A48, and the court can find that there is a factual basis upon which it is alleged that these accused perpetrated these offenses, or this offense in count 1, thereby handing in which would otherwise be inadmissible evidence. (1.8), my lord. The state is requested to set out in detail the acts that are attributed to accused 1, 2, and 3, and 5, in order to substantiate the allegation that they are guilty of the offense. My lord, my English is not, or rather, the English language is not my first language. But 1.7 and 1.8 seem to mean the same thing to me. Give us particulars upon which you say they have committed the offense. That's 1.7. 1.8, give us details of the acts which you say they have committed in order to substantiate that they are guilty of the offense. To me, 1.7 and 1.8 seems mean the same thing. Hence, if the court looks at 1.8 reply by the state on 39, reference is made to reply to 1.75 supra. May I be permitted not to repeat myself about what I've already mentioned in 1.5 supra?
All right.
Before I start with 1.9, my lord, the request for further particulars from page 18 up to page 36 seem to be this repetition of same questions. And my reply there too was always that you must refer to the answer given to 1.1.9. Therefore, my lord, when I answer 1.1.9 or 1.9 altogether, my submissions will also spill over to the same questions that are asked from the other counts on this further particular, so that I should not repeat myself. I will go to instances where it will be my submission that is different. Then I will give my submissions there too. But the questions asked in 1.9 are similar to all the other requests made up to page
18 to 36.
36, my lord, yes. But there are instances where there will be different questions, but I will go to those and give and make submissions there too. The state in 1.9.1, the state is requested to state who the accused were that acted in common purpose with each other, and to set out the actions attributed to each of such accused. And the answer there too on 1.9.1, the state submit this is a matter of evidence However, reference is made to statements and or affidavits already supplied to the accused in general and A48 and A77 in particular, and further reference is also made to paragraph 1 and 2 of part A of, maybe also correct that one, my lord, of the summary of substantial facts, instead of saying the summary of the indictment.
You love the indictment.
It appears. When I was typing, my lord, what was in my head is the summary of substantial facts to the indictment.
Ah, okay.
The summary of substantial fact to the indictment.
Yeah.
Hence,
Yeah.
at the end of the day, thank you, my lord.
No problem.
Therefore, we are saying the accused, all 5 of them, on paragraph 1 of part A of the summary, acted in common purpose with each other. On paragraph 2, we are saying the manner of such or how such was formed is presently unknown to the state. The actions attributed to them can be found from the statements already disclosed to the defense in general and in particular A48 and A77. The very same submissions I've made in paragraph 1.5 supra, my lords, are relevant here too. The state is further required, according to 1.9.2, my lords, to furnish the following. 1.9.2.1, what was the scope, mandate, and purpose of the common purpose? My reply thereto is just what I've made submissions to, my lord, on 1.9.1. Same applies. Who are the parties to the common purpose? Same reply. As to 1.9.1, I've just made submissions there too. How did each accused associate himself with the alleged common purpose? Same answer, my lord, as to 1.9.1. How did each accused further the interest of the alleged common purpose? Once again, 1.9.1. Exactly what role did each of the accused, 1, 2, 3, and 5, play in the furtherance of the fulfillment of the common purpose? The state is requested to specify or to specifically state what role each accused individually played. Once again, 1.9.3 is just an extension of 1.9.1. Because 1.9.1 said you must set out the actions attributed to each of such accused in the common purpose. And 1.9.3 says you must indicate what role they played to fulfill the common purpose, which is, to me, my lord, is one and the same thing. Hence, the reply thereto is the same. Page 19, my lord, 1.9.4. Is it alleged that the common purpose was derived by express agreement? If so, the state is requested to set out the terms thereto. There was a reply to this kind of question or request for further particulars insofar as accused number 4 is concerned, wherein the state did indicate that on paragraph 2 of part A of the summary, it is indicated that at precisely when, where, and in what manner the prior criminal arrangement was entered into is at present unknown to the state. Therefore, 84.2 finds application in this regard. I will take it therefore, my lord, that the rest of the question says, if so, you must then give the terms there too. However, we are saying you don't know the manner in which it was formed. 1.9.5, if it is alleged that it was inferred from the conduct and facts and circumstances, the state is required to specify the conduct, facts, circumstances, and utterances on which the state will rely in order to draw the said inferences. That's exactly the danger that I indicated earlier on, my lord. That the state now is requested to make a speculation, because those statements are not proven facts. That is, for now, that is just information, reduced into writing, taking an oath and making a statement. When the witness comes and gives evidence in examination in chief and being cross-examined, it will become clear as to the conduct of the accused or the facts and circumstances on which the witness will be testifying about, wherein the court can then draw the inferences to say, yes, they were acting in the furtherance of a common purpose. We have been warned by the case law not to speculate or not to expound and presuppose replies to evidence that will be tendered by the witnesses. Hence, my lord, we have to differentiate between the evidence and the information which will fairly illustrate the case that the state intends advancing. And we also in a position, or the accused are also in a position where they have the statements, wherein such conducts, such circumstances are indicated. Hence the reply by the state is reference is made to 1.9.1. 1.9.6, my lord. The state is requested to indicate and to state specifically if each of the respective accused was. Once again, my lord, if one looks at 1.9.6, it's just an extension of 1.9.5. Because if I give you the conducts and the circumstances and the facts, it will indicate who the main perpetrator is, who the co-perpetrator is, who is an accomplice, who is an accessory after the fact. If 1.9.5 I divulge those, it will indicate who those role players are. Therefore, that is why the response to accused, the reply in 1.9.6 is the same as that of 1.9.5 and 1.9.1. This is a matter of evidence. Once again, it was indicated by my colleague that he has read the statements and he could not find the answer thereto. How will the court then be able to make a ruling if there are two conflicting statements before it? The only open avenue is to read the statement or to show the court the statements, which will amount to evidence being brought before court, which is otherwise at this stage is inadmissible. Hence, it is a state submission that this will be a matter of evidence. At least it is indicated on the statements as to what accused 1 did, or what accused 2 did, or what accused 5 did, or whoever is accused did. My lord is well aware more than I do that, or rather the purpose of witnesses deposing to a statement vis-a-vis the evidence that the witness is going to give in court. A statement will be short, will be a short version of what the witness will come and testify about. If we speculate and say in line 2 of paragraph 3 of the statement, this is what the witness is saying, and the witness comes to court and give a detailed information, then we will be shooting ourselves in the foot by speculating, by giving speculative answers to requests for further party truths, which will be not, it's my respectful submission, in the administration of justice. Therefore, my Lord, it's my submission that the answers or replies given to the accused are sufficient or reasonably sufficient for them to prepare and submit their defense. Paragraph 2, page 19. Is it alleged that the conspiracy referred to herein resulted in the murder? I think there we are at idiom.
Just a second. You're referring to paragraph 2.
Paragraph 2 on page 19, my lord. Mr. Van der Merwe said the state second. Let me put it that. Let me use that term, second.
Right, thank you.
Then, my lord, count 2. It is the same questions up to.
Just a minute, okay.
Add count 2 on page 20. Up to page 22. Same questions that I've answered insofar as count 1 is concerned.
Same questions as in count 1.
As in count 1. Thank you for the correction.
No, no problem.
I will also submit that at count 3, same questions. At count 3 ends on page 24, madam. At count 4 on page 24. Same questions, my lord. Save for paragraph 6 on page 26.
Paragraph
6 on page 26 of the bundle, my lord. In which of the persons associated with the common purpose possession was where the alleged firearms? This is also a matter of evidence. And the law of evidence applies. And same can be found on the statements. Hence, the reply thereto is references made to 1.9.1. Why am I making this submission, my lord? I will try to argue by way of analogy. If X is charged with murder, and the form of the instrument you used to kill the deceased is a firearm, and there is enough evidence before court that the cause of death is by multiple gunshot wounds. I'm making an example. And the state's lead evidence that indeed X is the person who was seen firing shots at the deceased. And at the scene, certain exhibits were left, like your cartridge cases, what we normally call spent cartridges. And there is further expert evidence to say such cartridges are of a 9mm firearm. I'm making an example, my lord. And the state manages to prove that at the time of the commission of the offense, the accused, or X, did not have a license to possess a firearm. That is now a hypothetical case that I'm putting before court. However, throughout the investigation, this firearm is not found. There is sufficient evidence before court that at the time of the shooting of the deceased, the accused or X was in possession of a firearm, in view of the expert evidence that there's multiple gunshot wounds, cartridge cases found on the scene, and all of that. They were seen shooting. Now, the accused stands up and requests a further particular to say, who was in possession of a firearm? Or in which of the accused was the firearm found? It's not found. But inferences can be drawn from the proven facts that on the day of the incident, on the day of the shooting, he was in possession of a 9mm caliber sort of a firearm. The court cannot reach such a conclusion until such time that the court has been offered an opportunity to listen to the evidence of experts, the eyewitness, and all of that to come to such an inference. That's just one part of the law of evidence that I was referring to. However, the accused will be charged with the possession of the firearm at the time of the shooting of the incident, regardless of the fact that the firearm is not found. Will that not, my lord, be the matter of evidence? faced with such kind of a scenario, and the state is requested, in whose possession was the firearm found? And it is clear from the dockets or the disclosed statements of the docket to that particular accused that a firearm was not found. Should I then, or should the state then break it down? Say, if the court finds X, if the court finds Z, then the firearm was found in the possession of the accused. Well, it was not found. But at the time of the incident, this is the situation. Hence, it is indicated by Himstra. We should differentiate between the evidence and the information. The information is on the disclosed statement.
You differentiate between?
The evidence and the information.
Okay.
My lord.
I'm with you.
The information upon which the evidence will be based on is on the statements. Hence, the state's submission is on paragraph 6. Reference is made to 1.9.1. Look at the statements given to you. Look at A48 and look at A77. You'll find your answer. However, this is a matter of evidence. Just to stretch it a bit further, my lord. There is a principle of joint possession. Which principle the court can employ on the facts before it. And the court can find that even though there was one firearm and there are two persons, but both of them can be found guilty of possession of unlicensed firearm, based on the joint possession rule. But it needs certain facts for that inference to be drawn.
Joint possession will need evidence.
Will need evidence upon which inferences can be drawn. Now, if the state is then ordered and said, no, give a particularity insofar as this question is concerned, then I'll have to give the court the statements so that the court can see that on this information I can speculate, because at that stage not evidence. I can speculate the joint possession can be proved that A, B, and C possess the firearms. But we're not there yet. That is why we're saying let's leave it to be the matter of evidence. And not try to bind the state and say, no, the state must say it is accused number one. So that the state cannot come later and say, I'm arguing joint possession. Because now the evidence is here. But you said when you replied, it was accused number one where the firearm. Now I will change it. Because the further particulars are binding. Hence the reply is, this is the matter of evidence. However, you can find your answers, or you can infer from the statements already disclosed in general. But in particular, go to A48 and A77. It's my respectful submission, my lord, that based on what I've made, or based on the submissions made, there is no reasonable need for additional information. This is the matter of evidence. May I then go to paragraph 7 now, still on page 26. The state is requested to furnish accused 1, 2, 3, and 5 with section 212 statements pertaining to the analysis of the alleged firearms. If the court can just bear with me. The submissions made were by Mr. van der Merwe. We are not disputing that the section 212 statements were handed to us. However, we are asking the state to point us on those 212 statements, the relevant paragraphs wherein this answer is given. Why not say on your reply it is contained on this specific report? Say, for example, the report is A44 in the docket. Why not say that? My Lord, why should the state assist the accused in the analysis of the evidence? You are given the entire evidence. Here's the evidence the state is relying on. The rest is up to you to analyze the evidence that has been given to you. I've seen in my career where some of the accused even go to their own experts to say, I've got this expert evidence. Can you make me understand this? I've seen that happen. But this now says, tell us what you state, how you state, analyze your own evidence. I think it's my respectful submission, my Lord. It's going beyond. It's going beyond. The scope of Section 87 is there. If we look at this question, a reasonable need for any additional information? No, the information is there. All we have to do is to go to the right one. Study your docket, understand the evidence that the state has given you, and you will understand. Why do you need the state to say, go to paragraph 3.2.5 of H77? Further particulars is for a reasonable need for additional information, not what you already have. Hence, the reply there to my Lord is, on page 42, same has already been disclosed to the accused as part of the docket. When considering an application for particulars, the guiding question is whether the accused has a reasonable need for additional information in order to prepare and submit his defense. Cooper, Adams, and others. There is no need. You already have the information. Paragraph 8, art count 5, my lord. Page 28. Art count 5, 8.1, my lord, up to 8.4.6. Same questions as in art count 1.
8.1 up to
8.4.6.4 on
Yeah.
page 28, my lord.
yeah. You say same question.
Same questions as in art count 1. And then 9 and 10 on page 28 is the same question as 6 and 7 on page 26.
You mean you're saying 9?
9 and 10 on page 28, my lord,
Yeah.
is the same question as 6 and 7. It's just that
Oh,
it's
yeah.
firearms and ammunition. That's the only difference. Therefore, my submissions will be the same. Art count 6. From paragraph 11 up to paragraph 14.3.6.4.
Up to 14 point.
0.6,
Mm-hmm.
14.3.6.4 on page 30. Same questions as at count 1. Same submissions. Still on page 30, my lord. Paragraph 15. I believe this is settled. Because it's the same question as settled. It does an indication it is settled, my lord. Page
Right,
30.
Mr. Fundamental settled, isn't it?
Yes, indeed, sir.
Thank you.
Page 31, my lord.
Yes.
Paragraph 16.
Is it at count 7?
Art count 7, my lord. Paragraph 16 up to paragraph 18.2.7.4.
Okay, just a minute. Paragraph 16 up to?
Paragraph 18.2.7.4 on the very next page, 32.
Okay, just a minute. Yeah.
Same as art count 1. Art count 8, my lord, on page 22. From paragraph 19 up to paragraph 23.4 in page 34. Same as art count 1. Paragraph 24, my lord, on page 34, 34 rather. Is the same as paragraph 10 on page 28 about the 2 and 2 statements. So same submissions. Page 34, art count 9. From paragraph 21, rather 25.1 until page 36, paragraph 25.3.6.4.
Just a sec. Up to paragraph?
25.3.6.4, my lord, on page 36.
Okay, yeah.
Same as at count 1. Paragraph 26 on page 36, my lord, also deals with section 2 and 2 statements, same submissions made by the state. Therefore, we tend to under the paragraph general on page 36. The state is requested to indicate if any other prosecutions or attempted prosecutions other than the prosecution of the 5 accused emanated from the information gathered in the investigation of the matter and the resultant from the statements made by and obtained from deponents of the affidavits in the case docket. If so, give the full details as indicated, my lord. The police station case number and the identity of the accused, the court, and the relevant case number. The reply by the state to paragraph 27 is as follows, ma'am. In reply to 27.1 to 27.6.
That's 21.1, not 27.
Yes, my lord. I see I've changed mine here.
Is it 27?
It's 27.1 to 27.6.
Okay, just a minute.
Reference is made to reply to 1.2 and 1.2 supra.
Have you changed 1.1?
No, Lord, I'm saying the reply is on page 45.
Yes, I'm there.
It's saying in reply to 27.1
I have that. I have that.
to 27.6. Reference is made to the reply to 1.1
Yeah.
and 1.2 supra.
Yeah. No. I see. You actually hadn't said 1.1. You had said something else.
My apologies.
All right.
That is the first portion of the reply, my lord.
All right.
And the next portion is that the state submits the same is irrelevant to the present charges. Let me start with the first portion. 1.1 says the investigation in relation to others are at an advanced stage and sensitive stage. To disclose at this stage as to the number and the identity of those involved will jeopardize the investigation thereto. Therefore, my lord, there has been no prosecution in the sense of a person being an accused in court. However, there are investigations towards certain individuals. If one reads 1.1, if we are to divulge the case number and the police station details, then we'll be jeopardizing the very same investigations which are at a sensitive stage, because by divulging those information, you are giving away who the accused are, or the suspects are rather. By divulging the identity of the accused, I already indicated, my lord, that at this stage we have suspects because there's no case docket in court. If the accused was prosecuted, or if the prosecution was declined, or if the indemnity was granted to the suspect, the matter is still under investigation. It hasn't reached a stage where there's an accused person. Leading to the prosecution being declined or indemnity granted at this stage.
Okay, just a second. Mr. Alexander, accused number 4 is sleeping.
I'm terribly sorry, I haven't looked behind me once.
Yeah, no, that's okay.
May I just approach him?
Yeah, please.
Thank you. May I just ask that he stand up, Guy?
I beg yours?
May I just ask that he stand and approach me? I don't want to shout across. My lord, apologies. The accused number 4 has indicated to me in brief that he's exhausted. We are aware that, and I think it has been placed on record on numerous occasions, the distance that's travelled. But I do apologise, take full responsibility for that, and try and find a solution that this doesn't happen again.
Well, look, I'm almost in.
Okay, just.
I'm just left with two paragraphs that I have to respond to. One, actually. Yes, one.
Well, honestly, for my learned colleague, there might be even a solution to the one paragraph that he wants to address now.
Yes.
Outside. So maybe it might be a prudent time that we go our separate ways and see if it's necessary for him to address that one aspect. It's pertaining to paragraph 28, copies of a case docket. What else do you want to address? The other two has been said.
Oh, paragraph 28 on page 37.
37.
It's on page 37. That's
Yeah,
how
that's
I
what I
understood our agreement.
No,
The other two.
I said I would make submissions on those.
Yes, no, I said he wants to make submissions, but if we settle it, then the submissions are not necessary.
Oh, are you proposing that we settle?
That's what we have a discussion about now.
Okay, just a minute.
May we take an adjournment for a day, my lord, and deal with the two last issues
Tomorrow.
morning.
All right.
We should probably wait, my lord. May I just approach accused number 4 again? Thank you. I'm indebted to the court.
Okay, thank you. Right, tomorrow will be 26, is it not?
That's correct.
Correct, my lord.
The matter is rolled over to tomorrow, 26/5/16. You are in custody until tomorrow. You remain in custody. Sorry? I take it the time remains the same.
Yes, Madam, our state.
Thank you. The court adjourns.
Mina, better than you do swapping. Use medication. The prescription. What is the same?
If you can check everybody's you are